Most of you have seen criminal trials on TV, right? In those cases, the government has to prove that someone is guilty beyond a reasonable doubt in front of the jury. But in immigration, the burden of proof is on you and your attorney. The government doesn't have to prove anything. They're the judge and the jury deciding if you've met your burden that you're eligible for the benefit you're applying for. Hello, everyone. I'm Erick Widman, an attorney at Passage Immigration Law. We have offices in Oregon, Washington, and California. You can visit our website at passage.law or subscribe to our free newsletter for regular updates, tips, and the latest immigration insights. In this video, I'll cover what the burden of proof means in immigration cases, common mistakes in providing the proof, and what kind of evidence really matters to win your case. What is the burden of proof? Let's break it down. In immigration cases, the burden of proof is on the applicant, not the government. This means you must clearly prove you qualify for the benefit you're seeking. Whether applying for a green card or citizenship, strong, well-documented evidence is key to success. For example, if you're applying for a marriage-based green card, it's your responsibility to prove that your marriage is real. It's not enough just to send in a marriage certificate. You need to show that your relationship is genuine, not something created just for immigration purposes. USCIS officers are trained to look for red flags, and if you don't provide enough credible evidence, your case can be denied. But it doesn't stop there. Even after proving your marriage is real, you must also show that you're admissible to the United States. That means you can't have certain disqualifying issues in your background, such as serious criminal convictions or past immigration fraud. Every single question on Form I-485, the green card application, is designed to uncover reasons you might not qualify. If you can't prove you're admissible, no green card will be issued. So, where do most people go wrong when trying to prove their case? I've seen families torn apart because they didn't know how much evidence was enough. Many of them ask the wrong question. What's the minimum amount of evidence I can send in? That mindset is risky because USCIS is not trying to help you get approved. They're simply deciding whether the documents you submit meet the standard. If they don't, your case gets denied. In 2025, a denial could seriously jeopardize your immigration status because USCIS is issuing more NTAs, notices to appear, and starting removal or deportation proceedings. So what kind of evidence actually carries weight with USCIS? Let's start with one of the most misunderstood types, letters from friends and family. These can help, but only if they're done correctly. USCIS often ignores letters that don't include a formal declaration. The right way to submit a letter is as a sworn declaration or affidavit signed under penalty of perjury. The writer should state facts they personally know and include details about your relationship and your life together. However, make sure each letter is unique. If you submit multiple declarations with identical wording or structure, USCIS may see them as copied or inauthentic. This will weaken your case. Photos are another good form of evidence, especially when they show you and your spouse at different events with different people over time. But make sure to add captions explaining who is in the photo, when and where it was taken, and what the occasion was. Context matters. Still, the strongest type of evidence for couples is financially and legally integrating your lives together. This includes joint bank accounts, shared leases or mortgages, tax returns filed together, matching IDs with the same address, utility bills in both names, and other documents that show you're living a real shared life. If you've kept things separate for tax or estate reasons, that might make sense personally, but for immigration purposes, it does make your case harder to prove. Also, don't forget that any documents in another language need to be translated, and you also must provide a certified translation. If you don't, you risk rejection or denial of your application, delays in processing, possible loss of your priority date, and wasted money and time. The reality is, immigration cases aren't criminal trials, but they come close in the sense that the stakes are high and the rules are strict. At Passage Immigration Law, We don't just fill out forms. We build cases designed to win and represent you through the entire process. Winning in immigration means doing more than just the basics. It means going above and beyond to meet your burden of proof. If you want help putting together the strongest case possible, reach out to us, 503-427-8243, or visit passage.law to schedule a consultation. If you know anyone who could benefit from this information, share this video, because information is power. If you have questions, drop them in the comments below. Don't forget to like and subscribe for future updates, because knowing how the system works is key to succeeding in it. Thanks for watching, and stay tuned for our next video.